Greetings, Twitter. Greetings, YouTube. I wasn't planning on doing a live stream tonight, but given that certain news stories have broken today, one respectively as of maybe an hour ago, I felt kind of compelled to go live with this. Let me start from the beginning. Let's get at it. As you probably were aware of, at one time there were two lawsuits. Let me backtrack just a little bit before that. The federal government issued a guidance a few months ago with respect to EMTALA, which is the emergency medical, I wrote the acronym for it. It's part of the Social Security Act, I believe. And the guidance they issued was with respect to abortion being an emergency medical treatment in the event the life of the mother or the child was in danger. And they passed this through the Health and Human Services Agency of the federal government, backed by the Centers for Medicare and Medicaid. Now, two lawsuits were filed against the guidance. One lawsuit was filed against the guidance by the state of Texas by Attorney General Ken Paxton. The other lawsuit was filed by the Department of Justice, the DOJ, against the state of Idaho. So we have these two lawsuits. Basically, it's the same legal case in a nutshell. This morning, news broke about a ruling issued last night by the federal judge in Texas. The federal judge in Texas ruled to block the guidance because the guidance is not, the EMTALA directly does not, these are words from the actual ruling, the EMTALA does not specifically authorize abortion. Now, in that lawsuit, the judge, the gist of his ruling was based on what's called the Chevron framework. He goes to say that because the EMTALA says that it applies to the mother and or the child, it applies to both. Technically, you can read it that way, but when the decision has to be made by the doctor to save either the mother or the child, unborn child in this case, the EMTALA specifically makes it an option, either or. And so, in essence, what the judge is saying is contrary to the wording of the EMTALA in that sense. And that's the point that I've been making. I actually tweeted a comment this morning, a lengthy comment of my opinion, to the Attorney General of Texas talking about that. Now, in that comment, I specifically said that, because I started the comment saying, okay, the Attorney General is going to claim a victory in this specific lawsuit because of a ruling that was issued. But I said he should not assume that it is a total victory, because of the fact that there is still a pending lawsuit in Idaho, which in the same two articles that I read said that the ruling was going to be, or that they were going to hear the case this afternoon. And I said, because this lawsuit is still pending in Idaho, he can't claim a total victory on this specific issue. Because if the state of Idaho ruled in the opposite direction than the federal judge in the state of Texas, that we would have I guess you could call a split precedent, because you'll have two federal judges ruling totally differently on the same legal issue. Well, this evening, in the state of Idaho, the federal judge there blocked the abortion ban issued by the state of Idaho because the guidance and EMTALA apparently supersede this ban, this state law. Now, everybody knows, and for those of you that don't, I'll make a clarification, that when an injunction, a preliminary injunction, because it's a preliminary, then you're still going to hear the case. But whenever a preliminary injunction is issued, it's most likely issued because the party requesting it has sufficient merits to win the case. So the judge in Idaho is saying the U.S. stands a chance to win their case, whereas the judge in Texas says that's not the case. The state of Texas stands to win their argument. You've got two judges ruling in two totally different rulings on the same topic. What has to happen next? Well, in theory, each case should go to the appellate court. Now, if that's the case, and they do, and the rulings stand, then it would have to go to the Supreme Court. Now, for a ruling, because these are two different jurisdictions, and this is where I was going to get at, because these are rulings in two separate jurisdictions on the same issue, it stands to reason that the case must go directly to the U.S. Supreme Court. Now, the question is, how is the U.S. Supreme Court going to rule? Now, one thing that the judge in Texas did not, at least in the amount of the ruling that I read, there was something that I had mentioned previously when I touched on this subject a couple of months back, and that was that these lawsuits are about a federal regulation in the Social Security Act, which is federal law. How do you apply a Supreme Court ruling, which is Dobbs versus Jackson, that deals with what was the word I was using before? Using an inferred right granted by a previous Supreme Court judgment, which is Roe versus Wade. Can you use that argument when you're arguing against a federal statute? I don't think so, because it's two totally different things. Now, I may be wrong, but the judge didn't touch on any of that in the Texas case. The Texas case, he's basically saying because there is no clear, he uses the Chevron framework, saying that because the EMTALA protects both, that the United States has no case. And he talks about that in two specific points. But the thing is, the EMTALA is saying that the doctor has to elect treatment to save either the pregnant mother or the unborn child. So there is a choice there in the EMTALA. Something that the judge clearly in his ruling, he did not specify, or he specified to the contrary. I have not read the Idaho case. I will read it this evening if I can, and I will tweet a comment on it tomorrow. I want to look through that to see exactly what the judge said and compare the two lawsuits. But I felt it prudent to come live and talk to you about this, because there are two rulings on the same issue, same legal case, two totally different rulings opposite of each other, and because of that, just as the Idaho case validates the Department of Justice, the Texas case validates the state of Texas, but because there are conflicting rulings, you can't in either circumstance claim a victory. Texas can't claim a victory against the United States government, just as the U.S. government cannot claim a victory against the state of Idaho. Because if you look at that particular case, you're like, okay, the U.S. won this, but they have a ruling against them in another state. So the same measure applies in Idaho that applies in Texas. I would say to the U.S. government, you have an opposite ruling in the state of Texas. You can't claim a victory just yet. And to the Attorney General of the state of Texas, I have said the same thing. Because there's a ruling in Idaho contrary to your ruling that you were given in the state of Texas, you cannot claim a complete victory at this time. So this is basically what I wanted to express. And I also wanted to respond to a very unique comment that I got on the comments that I posted this morning. The person said something to the effect that it was too long and they didn't read my comments, but they tacked on a little comment saying it's impressive it's impressive what you're saying about murdering babies. That's not the pretense of my comment. My comment is basically an analytical, talking about the ruling in a legal sense. My comments with respect to this topic, I reserve specifically in reviewing the lawsuits and giving my comments about the actual legal ruling that is issued. So I found the comment ironic, and I found it humorous. I found it curious because that was not the purpose of my comments this morning. I basically went to comment because I knew the Attorney General was going to claim a victory here in the state of Texas. And I knew, based on the two articles that I read, that the ruling in Idaho was pending, that they were going to have a hearing today. I didn't know they were going to actually issue a ruling. That was surprising to me. But I knew they were going to hear the case, and I wanted the Attorney General to be aware that there was another lawsuit on the same issue that could jeopardize the ruling in Texas. Now, you say, how would it jeopardize it? It would jeopardize it because if the U.S. were to appeal, let's say, if they were to appeal the Texas ruling in the Fifth Court of Appeals, they can say we have an existing ruling, an existing precedent in Idaho that has been given to us blocking an abortion law. Now, the Fifth Circuit Court of Appeals cannot overrule that ruling because it's a different jurisdiction. So, in essence, that argument would be compelling enough for maybe the Fifth Circuit to say, okay, we're going to reverse the ruling, or we're going to let it stand and you need to take it to the Supreme Court. They may even refer to the Supreme Court because there's an intrajurisdictional issue with this case. I mean, anything's possible. And the same thing could apply in Idaho. Let's say Idaho wants to appeal it. They can come back and say, well, there's an existing ruling or injunction in Texas in our favor. And the appellate court the appellate circuit court for Idaho would probably do the same thing. So either way it goes, it's going to end up more than likely going to the Supreme Court, is what I'm saying. So this is something that we're just going to have to wait and see how it plays out to see where it goes from here. But as I said, I just wanted to basically explain this because of the news coming out of Idaho earlier this evening about the abortion ban being blocked in favor of the federal guidance. Well, thank you for your time. I will try to read the ruling for Idaho here shortly, and I will come back to do another live maybe tomorrow to talk about both lawsuits in a little more detail, because I do find it interesting that there's a split precedent, and it is something I think worthy of going into and analyzing and discussing it. So have a good evening, and until I see you again on the stream, take care. Have a good night.